Hey YouTube family, it's Humberto with some good news updates. I've been bringing you good news during this COVID-19 pandemic, and guess what? Family-based petitions, the interviews are being waived. Premium processing is back. If you have a case and you want it adjudicated an I-129 or an I-140, you want it adjudicated within 15 days, well, it's back. Thank goodness it's back for these non-immigrant visas. So we'll go into some detail. So the first bit of good news is family-based petitions, the interviews are being waived. How do I know this, guys? I know this because I'm going to give you information from what happened in my office last week, okay? These are actual cases where the interview has been waived. Okay. The first case is a family-based petition. That was a really interesting case. The petitioner died. Most people believe that if the petitioner dies on an I-130 petition, that's it. You can no longer get a green card, okay? Well, that's not true. So this particular case was very interesting because I filed the adjustment under what's called a humanitarian reinstatement. There's two ways to do it, right? The first way is through what's called a humanitarian reinstatement. You just have to show positive factors, negative factors. You have to have an affiant in the US, and you can file your adjustment. Now, immigration was confused. There's another section of law for humanitarian reinstatement, and that is under 204, Section 204. Now, Section 204 requires that the beneficiary, the person that's getting the green card, that they be in the U.S. at the time of the petitioner's death. Under the humanitarian reinstatement, there's no time frame. I mean, my client actually came from Peru on a visitor visa. The parent had died years ago because it was a family third-based petition and it took a long time to adjudicate. So they were in Peru when the petitioner died, came to the U.S. on a visitor visa. We filed the adjustment. Now, here's the interesting thing. At the time of the interview, that's when the officer exercises discretion. It's a discretionary petition. So what happened in this case was we filed the adjustment. There were a few RFEs because immigration was confused over humanitarian reinstatement versus 204. My client was actually scheduled for an interview right before COVID hit. The interview was canceled, and just last week we received the approval without an interview. The green card came. Second case, I-751 petition. This is a joint petition where the married couple files together to remove the condition. They had a conditional green card that's good for 2 years. Then you file what's called the I-751 petition to remove the condition. My client filed the I-751. I guess this was about 8 months ago. Okay, so they filed the I-751. Generally these days it's taking 2 years for that I-751 to be adjudicated. Well, guess what? Last week, green card came in the mail, interview waived. So this tells me, and I told you before, you know, I saw in my practice the employment-based petitions coming, approved, interviews waived. Now I'm seeing family-based petitions, approved, interview waived. Why? Immigration is backlogged, folks. I mean, they are backlogged, so they have to do something. I think this is one way that they're going to do it, is waive these interviews. Let's hope it keeps coming. Second bit of good news, satisfactory departure. So I had a client just last week who got the second satisfactory departure approved. So she's gotten up to 60 days to be here on the ESTA. You know, generally when the ESTA expires, there's no extension, there's no change of status, there's really nothing you can do. So that's a bit of good news that she was able to get 2 satisfactory departures. The first was granted for 30 days. She applied again. It was granted for 60 days. So that's good news. If you file your request for satisfactory departure beyond 30 days of expiration of your I-94, they will automatically deny your request. But in this case, my client did not file it after 30 days. He actually attempted to file right after his ESTA expired. So he applied again. He showed the correspondence and the time frame that he was trying to get the satisfactory departure request adjudicated by immigration, and they approved it. Okay, so it was once denied incorrectly that he did not make an application prior to the 30-day period of expiration of his I-94. He applied again, he tried again. I advised him, give proof that, you were trying to correspond with immigration. So he did that and it got approved. So that's pretty good news. So another bit of good news, I-90 petitions. So this is where your green card is not expired, but it has to be renewed. A green card generally, the physical card is good for 10 years. It's kind of like a driver's license, where you need to take a new picture, take some fingerprints, make sure you're not a criminal. In any event, this is the I-90 petition. Or if you lose your green card, you can file this I-90 petition for replacement of your green card. Generally, it was taking 8 months for these I-90 applications to be approved and the green card issued. I had 5 last week, 30 days, folks. It took only 30 days. That's great news. So if you have an I-90, get it filed now. You can get your green card quickly. Finally, premium processing is back. So premium processing is a 15-day processing where you pay $1,410 and immigration will adjudicate your case within 15 days. They suspended premium processing January of 2020, in some cases even prior, but they've brought it back. So the I-129 petition and the I-140 petition are the applications that were suspended. I-129, those are for non-immigrant visas. The I-140 is for employment-based green cards. Those were suspended, so now it's been resumed. The I-129 petition, it's broken down into stages where you're eligible to file for the premium processing on certain H-1B petitions, L-1s, R-1s, etc. If you go to uscis.gov, it lists exactly the dates. One date is June 1st, it resumes. One date is June 8th, June 15th, and June 22nd. So they're allowing I-129 petitions to resume in stages. I-140 petitions, June 1st, we're back at it. So if you have a case, an I-140, let's say an EB-1 petition extraordinary ability, and you want to premium process that case, you're able to do it now. That's great news, guys. Again, I'm going to bring you good news, guys. If you want bad news, go to another channel. It's not going to happen here. I'm going to dig. Every week I'm going to find something good, and I'm going to bring it to you. Stay safe. Thanks for watching GrayLaw TV. Click below, like, and subscribe.